I think we have now enough participants between those here in Paris and those in the virtual meeting room, and we can then start the open hearing on the draft RTS on participation requirements. My name is Nicoletta Giusto, CCP Supervisory Committee independent member and director for policy and supervisory convergence here at ESMA on CCPs, of course. I have with me several members of my staff that will be ready here to interact with the audience. This is a public hearing, so the aim of it is for us to get as much as possible feedback from you, and I assume that you have. Please mute the. Okay, thank you. You have read the draft consultation paper, the various, the explanatory part, and the draft RTS. So we are not going to have a long presentation. I'm just sketching for you the background. Just one moment that more participants are joining. And then we will show you the few slides. So, as you know very well, the famous EMIR 3 amended Article 37 of the old regulation dealing with participation requirement. This was done particularly due to the experience gained through various crises that occur during to the fault of participants or because of the commodity crisis, the difficulties that a number of non-financial had to keep up with their margin payment and their obligations stemming from participation, either direct or indirect, in the activities of CCPs. The main changes deal with non-financial counterparties. Indeed, CCPs now can accept non-financials as clearing member only after having ascertained that those non-financials are able to demonstrate how they intend to fulfill the margin requirements and the full fund contributions, including in stress market condition. I already alluded to the crisis. Client clearing services by non-financial counterparties are limited only to other non-financial counterparties belonging to the same group. ESMA was therefore tasked to develop draft regulatory technical standards to develop the elements to be considered by a CCP when establishing its admission criteria and assess the ability of non-financial counterparties acting as clearing member to meet margin requirements and default fund contributions. So, and this is very important to understand. What ESMA is doing is not to regulate directly the admission criteria, is to set out the criteria, the benchmark, if you wish, that the individual CCPs will have to look at in drafting their own admission rules and then assessing applicants for being admitted as clearing members. There are several elements that we have touched upon in our proposal, both for financial counterparties and non-financial counterparties, which are the various sections on which we would like to discuss with you. Financial resources, operational capacities, various risks like legal risk, etc., additional elements for clearing members that clear on behalf of clients, and also additional element for sponsored access model, which is a feature nowadays very common in many CCPs. But before we open on the first element where we want to get your feedback, the financial resources, I would like to ask whether from the audience there are general comments or questions for us. I see one from the room, Rafael.
Thanks, Nicoletta. Perhaps just one general comment on my side on behalf of the CCP community within each. And it's the point that you made that I think is very important when you say something along the lines of, well, we're not trying to regulate exactly how CCP should be doing things. I think that's something that we very much appreciate. We've seen that you have not just like listed every single criteria that CCPs need to apply, but it's more, this is a framework, and then it's up to CCP how to interpret. So I think that's great news. We do have definitely some comments, but definitely the strategy, we very much appreciate that. Thank you.
Thank you, Rafael. Indeed, that is our approach. As I have said, that it is important because it may not be immediate to understand. Any other general comment from the virtual room? I don't see any. Then perhaps we can open the discussion on the element of financial resources. Of course, prudentially supervised entities, they have their own capital. Non-financials that are not prudentially supervised, they don't. This is one of the elements that will have to be ascertained, assessed by the CCP when accepting them. We would be interested in knowing whether we got the balance right in the way we approach this topic. Rafael, I see that you are already.
Okay, let me start. And by all means, I speak under the control of the members like Alexandre, Julian, and all those online. Right. So on the first one, several points. The first one, and probably the most important for us, is something that we see elsewhere as well in the articles. And we understand that the idea, as we said, has been to create a framework, not to do criteria. That's fantastic. But it's a genuine question. We wonder, we think that the text as it is, for us, it reads as if the CCP needs to replicate the risk management that they do on a day-to-day basis when applying the admission criteria, because they are asked to look into the future, to do forward-looking scenarios. And that's something that came a bit as a surprise. And to be very honest, very transparent, I think we from CCPs, we said, but this is massive work for us, the way we read this. And it may be that we misread them, but the way it is read, probably our compliance teams would also read it that way, that we actually need to apply these stress tests. We need to look at future portfolios. And that is not something that CCPs would do on the admission criteria. So I think that's a very important point that applies to these, but also to other articles in here. And of course, we'll be happy to provide the concrete elements of what we mean. But if I just take some examples in Article 2 on financial resources that you're referring to, Nicoletta, well, the CCP will need to look at the margin calls during a market stress event, notably during periods of high volatility, increase of risk portfolio of the clearing member due to an increase in the activity. So again, it's a lot of forward-looking elements that from our point of view is part of the, absolutely should be part of the day-to-day risk management of the CCP, but not of the admission criteria. Otherwise, it would be extremely burdensome, and in some cases, even speaking under control of the colleagues, even impossible to apply at the beginning. So I don't know if Alexandre, Julian, or others online want to come in. Yeah, please.
I'm happy to add to that. Maybe just to be clear on the order of the question, do we want to discuss the point on fair and open access, or do we go straight to the point on financial resources? Because I also had comments on fair and open access.
Well, if you have then comments on the fair and open access, you can do, but our idea was to deal with the specific elements of the.
It's very specific. It's on Article 1, and I think it's a general observation. We've noticed a bit of a difference between the explanatory part of the RTS and the RTS themselves. And one example, for example, that has triggered a bit of concern for us is the transparency of the admission criteria and the rules. Fine, that's what we do under EMEA, and that's the obligations we have. It's on our website and so on. But the text also talks about the transparency of procedures, not in the article itself, but on the explanatory text. I think there's a bit of concern here that we are asked to publish some of the procedures or internal things that we use. For example, internal credit scoring, internal process that we use to manage risk and so on, which would be a concern for us to publish. So my interpretation, it's just me, is that it's a bit of a dichotomy between the two, and it's just that that's not what we mean to do. But I just wanted to flag that because that raised a lot of concern internally.
Okay, noted.
And
do you have something still on?
Sorry, I don't want to disappoint you. Yes, I do. On financial resources, I think to Raphael's point, there's a big difference between being able to take into account some elements for admission of a clearing member and essentially looking at its capacity in terms of the trading capacity, the portfolio composition of the clearing member and so on, to be able to say, well, I'm comfortable that with the activities you have elsewhere, you are going to fulfill those obligations. And that's a big difference. Is sometimes we feel the proposal is shifting a bit responsibilities on the CCP, and is essentially saying you become a first line supervisor on the ability of the clearing member to sustain the obligations and so on, rather than just than your core function, which is to manage default and make sure that you have the right admission criteria and onboard the right people. So I think it might be a matter of balance and on how we qualify the obligations. But I say it sometimes feels that on financial resources in particular, we're being asked to be first-line supervisors and first-line prudential supervisors, which is not something we're able to do.
Thank you. Noted. We have Ulrich from I don't know where. Maybe I forgot to ask you to introduce yourself before taking the floor. I know that is not in Europe or I couldn't make it in person, but please, Ulrich.
Yeah, so Ulrich Karl is I'm in New York at the moment. So sorry I couldn't come person. Really would have loved to. So I have a few points. And quite surprisingly, usually kind of Raphael, I disagree in these meetings quite a lot, but I had to agree with kind of his point about criteria not being specified. I also think I agree with Julien, the point with that obviously CCPs shouldn't become supervisors of their clearing members. But I also agree with the point he made on that it's probably a question of balance, because you would kind of think that as a clearing member, you're also reliant with the CCP kind of doesn't let every Yahoo in. So you have to rely on the CCP do proper due diligence, and I think that's pretty much what Julien actually meant. So I think it's a question of balance. I think the CCP needs to kind of be comfortable with the risk management framework, but maybe not really, as Julien said, kind of become the de facto supervisor. I have two more points. One, maybe I should have said, put my hand up earlier. Kind of it was more kind of fair, transparent access, where we talk about proportionality. And there, just I would like to make a point that I think proportionality is nice and well, and in terms of financial requirements, that kind of flows anyway, because a smaller firm will have smaller portfolio and therefore kind of don't need that much capital. But if you look at risk management capabilities, I think there is just a level that everybody has to have proportionality or not, because you probably, with hindsight, you wouldn't have said, "Oh, Mr. Einer Arns, you kind of, I know you're just one guy. We waive all the risk management stuff." So I think there is just a minimum level of capabilities, especially in risk management capabilities and operation capabilities firms have to have. And then the other point I was making was, I think the chimes as well with what Raphael and Julien just said is, especially this point, I think where you say that a clear member needs to have resources that also cover future changes to the portfolio, which I think is very difficult for the CCP to identify what these future changes might be. And I think Einer Arns might be a good example again, because maybe when he joined the CCP, he was doing, maybe he wasn't doing the trades he then later did. I think for that one, probably the trick is more that the CCP is using other tools like limits or kind of margin add-ons that are driven by some kind of a ratio between portfolio size and the capital somebody has, which I think is kind of we see in the market already with CCPs, instead of making that actually an admission criteria. And that's the points I have for now. Thanks.
Thank you, Ulrike. I think it's Raphael, no? The time.
Yeah, I just put it there to make it easier for you, so you can see me there. And others can see also online. So three more points on this financial. In addition to that, one that I'm very glad to hear Ulrich, the clearing members agreeing on that, because that's fundamental. So three more points. The first one is regarding the access to regarding the CCP checking clearing members having access to reliable credit, liquidity, and FX facilities. So of course we do check that, but the way that we do to check that is we rely on confirmation from clearing members that they have access to these. We as CCPs don't check and verify on a continuous basis that clearing members have access to all of these. We rely on their due diligence and then saying, yes, we do. If we are to do that, that requires probably massive full-time employees increase at the CCP. So that we'd like to flag. Two more related points on the credit worthiness assessment. Again, similar. There is a wording somewhere in the wording it says where necessary, the CCP may rely either on external sources or on the client information. And we understand this where necessary probably suggests that it would be preferable to have information from the client directly, but this may or may not be always possible, and again, it may require substantial resources. So just if we could get rid of that word necessary, I think that would be extremely helpful. And then finally, there is a reference to the group that the clearing member belongs to, and their eventual outsourcing relationships that the group has. And on this one, it would be quite challenging for the CCP to perform in-depth review of the clearing members group external outsourcing relationships, because that could be massive. So we would have quite a concern on that one as well. Yeah, thank you.
Other comments on this article on financial resources, particularly non-financial counterparties? Is there? No, that is the records. I don't see any hand from the audience here, from the room. Then perhaps we could ask reaction on the rules on operational capacity. Jean-Pierre?
Thank you, Nicoletta. Jean-Pierre from FIA. Again, we're still assessing the consultation, so we are working with our members on this, and I also speak under the purview of our members. But for operational resilience, I know that bank clearing members comply with all of DORA's requirements. So we're speaking to our clearing member and our NFC community to make sure that standards and expectations are similar when it comes to operational requirements. Also for margin transparency, that's a separate issue, but we are assessing indeed to have a level playing field when it comes to some of those requirements.
Yeah.
Rafael?
Thanks, Nicoletta. So fully agree with Jean-Pierre. I think that is again another of the main points that we have on this on operational resilience, in the context of trying to well, I'll use the term to simplify unnecessary regulatory burden. If a clearing member already complies with DORA and is checked for this, why would CCPs have to go and check all the operational checks and make sure that the clearing member complies? If they're complying with DORA, can we just take that as, hey, they do and they're compliant? That would be a relatively straightforward way. So then the question, if that were to be applied, the question would be for non-financial clearing members, that they do not necessarily have to comply with DORA. And even for those ones, we think that a more proportionate approach could be applied, because going back to what I said before, according to the text now, the CCP would need to check on an ongoing basis, based on how we read it, the compliance with operational requirements for non-financial counterparties. And again, that would be massive. And what we still analyzing, as Jean-Pierre said, the proposal, but what I hear from the CCPs that have non-financial clearing members, they said, well, this could prevent quite a lot of clearing members and even us from clearing those markets if we need to do that on an ongoing basis. So that we would call for that to be a more proportionate approach. Then there seems to be a requirement in paragraph 2 that, from our point of view, the way we read it, would suggest that the CCP would become part of the IT change process of a clearing member, and potentially even the independent members. And well, considering that CCPs, they may have hundreds of clearing members, that could be really overtly burdensome from our point of view. So I'd be happy to hear if we have perhaps misread that. And then regarding the backup arrangements, the operational resilience and backup arrangements, if we could just obtain confirmation through the due diligence questionnaires where possible, if not through the compliance with DORA, that would make our lives so much easier as well, and use of the usual of the usual sort of business approach, but requiring the CCP to actively verify every backup arrangement, that, I mean, it's impossible for us to do so. So requiring more on those due diligence questionnaires that the clearing member says yes we do, then that would be hopefully a more straightforward approach. That's the way we do things at the moment. Thank you.
Pablo, and then Julien.
Hello, everyone. I'm Pablo Iglesias from the University of Sussex. Sorry, I couldn't make it in person to Paris today. So when it comes to the requirements concerning access to accounts, adequate expertise, proper policies and procedures on risk management, business continuity, I think the proposals generally capture the scope of non-technological operational risk fairly well. My main concern is related to the topic, one of the topics Rafael was talking about, which is the issue of compliance of a clearing member with DORA, and more specifically, with Recital 16 and Article 3 of the proposed delegated regulation. So according to this, when CCPs assess operational capacity and resilience of clearing members, they must consider compliance of a clearing member with DORA. And more specifically, Recital 16 adds a statement to the effect that, to avoid any doubts, the fact that a clearing member is not subject to DORA doesn't mean that the CCP can automatically disqualify an entity from becoming a clearing member. So I have some reservations about this. Now, if the purpose of this clarification is to specify that the CCP cannot automatically exclude a clearing member that does not fall under the remit of DORA, according to Article 2 of DORA, which is the article that specifies all the entities that to which DORA applies, then I can understand the purpose of the clarification, because many non-financial counterparties are not covered by DORA, and therefore this would result in their automatic exclusion. However, if the meaning of this clarification is that a CCP cannot make access of a clearing member conditional on a clearing member, financial or otherwise, fully complying with the substantive obligations set in DORA, then I would disagree with the approach. Indeed, I believe that it might be beneficial for clearing members, regardless of their taxonomy, to be DORA compliant. And I think this for different reasons. The first reason is that a common unified application of DORA to all clearing members would foster consistency. Under the proposed regime, we would have financial counterparties acting as clearing members that are subject to DORA, non-financial counterparties, which in principle would not fall under the remit of DORA. And one of the effects of this fragmentation is that we would have different clearing members being subject to different requirements in terms of operational resilience, which, in my opinion, is not ideal from a prudential point of view. It would also mean that different types of entities would operate on an uneven playing fields, at least with respect to their performance of their roles as clearing members. I mean, more generally, from the point of view of prudential regulation, I believe there is a strong rationale for all clearing members being subject to DORA, because clearing members perform critical roles in terms of financial stability. Now, ideally, in my view, this could have been specified in DORA itself, which is not the case, because DORA does not follow a functional approach in this respect. EMIR could have also addressed this, but it has not, and ESMA cannot impose DORA compliance as a requirement for clearing members through technical standards. However, I do not see any regulatory impediment for allowing CCPs to require all its clearing members being compliant with DORA. This would not be in breach of EMIR. Section 1, Article 37 determines that the criteria to restrict access is allowed as long as it's useful to control the risk of the CCP, and requiring compliance of clearing members with DORA would indeed be beneficial in terms of risk mitigation for the CCP. Also, this requirement would not be in breach of Section 7 of Article 37, which requires ESMA to ensure proportionality when it develops the technical standards. And one of the reasons why there is not a breach of proportionality is that DORA itself embraces the idea of proportionality in Article 4. It allows entities that are subject to it to implement the obligations set in DORA in accordance with their own features, their own risk profile. So, in light of this, in my view, it may be advisable to remove any reference that suggests or conveys the idea that CCPs are not allowed to require clearing members to comply with DORA as part of the admission criteria, or at least clarify this aspect. I mean, in the end, a CCP could develop admission criteria that fully aligns with DORA. So I think it would simply be easier to allow and even encourage CCPs to require clearing members to be DORA compliant. Also for the consistency reasons I mentioned before. Now, to address the concern raised by Rafael, that is the load that this would impose on CCPs in terms of checking compliance. I mean, even the mere requirement of compliance with DORA, I think, sets a good incentive for clearing members, regardless of the the specific degree of, to which the CCP checks that compliance. I mean, in the end, a clearing member that says that is complying with DORA is liable if it's found not to be compliant with that. So that would be a different matter. So this was my main point on operational resilience and capacity. Thank you.
Thank you, Pablo. Noted. Julien.
Thank you. So I do have a comment on this part, but I would say it's a slightly different angle. The idea that a CCP takes into account the fact that a particular entity is subject to a particular regulatory framework doesn't seem shocking as such. We have it in the financial obligations. If you are credit institutions, that's a very strong signal already for a CCP that you are being supervised, and that's the whole point of the difference between financial counterparties and non-financial counterparties. So I have a slightly perspective on that, which is the fact that you are subject to DORA is a sign, and you might take it into account in whatever assessment you're doing. It's not the alpha and the omega of the assessment for operational resilience, but it can be an element. Where I'm struggling with, and where I think I'm coming back to the point I was making in my general comments about being a first-line supervisor, is that the text says we're checking if the clearing member complies with DORA. That's fairly different. Because if you say you comply with DORA, that means that implies that we need to check if people actually abide, not only subject to it, but abide into it, and it puts in place a kind of a control of the compliance with DORA. So I take a lot of the comments that have been made. In philosophically, I understand the idea that if you are subject to DORA, by definition, you should have some operational capacity, operational resilience, sorry, not operational capacity, that's very different. But the comply point is what is, in my view, the most problematic. And just to come back to the general point on operational capacity, I mean, we test, all the CCPs will test the operational capacity of a clearing member, because you want to make sure that they can connect, they have the settlement capacity, they have the communication capabilities, and so on. So it is something we do. And a lot of the obligations in there, we would test, but in a slightly different way than the RTS would propose. So for example, when I think sometimes somewhere we say that we need to check, essentially, if we need to check the knowledge of the people we have in front of us, we will not do that. We will not test them and say, this is a survey or questionnaire, tell me, respond me, you have 30 minutes and tell me whether it's good, whether you understand or not. It's more, we're testing the capability to respond to events, we're testing all these capabilities. And we would offer training, saying this is how the CCP functions. We offer training to clearing members if they have any doubts or anything, to make sure that they are up to speed on how everything functions. Where I'm struggling a bit also on this part is the implication that we would be, effectively doing kind of a bit of a testing of, what are the qualifications of your people and so on, which is, it might be again going into the first line supervisor aspect I was mentioning.
Thank you. Ulrich.
Thanks, Nicoletta. I just have not such a smallish point. So I think I roughly agree with Julien. Maybe just should have made a disclaimer before. Whatever I say, we are still in discussions with our members, so it's not a finally formed is their opinion. I'm more or less just offering thoughts. I think I agree with most of the things that Julien said. What I a bit noted is kind of a bit earlier in the discussion that it went a bit towards saying we have DORA, so the whole operational resilience thing doesn't need to be looked at, and if we have to do it only for non-financial counterparties. But on the other hand, there are a lot of European CCPs or CCPs falling under these rules that have non-European counterparties, but are probably not subject to DORA, or kind of maybe similar rules, but not that. So I would think that the way to do it is still the CCP needs to have requirements, and if it happens to be, if somebody is subject to DORA and is complying with that, and I agree again with Julien, CCP probably shouldn't be maybe the first line of defense to actually kind of be the auditor for that. But if a clear member complies with DORA, that obviously can be good in the indication that these criteria are met. But I think the CCP will have to have the criteria anyway for non-EU clear members, at least if they have them. Thanks.
Thank you. And then, of course, we look forward to receiving the responses to the consultation, but we offer this open hearing precisely whether you could already give us your first reactions. Any other from the virtual room or from the room here in Paris? I don't see any hand raised. Perhaps we can move to what is for us Article 4. So it's additional considerations and risks like legal risks. Rafael.
Yeah. No, yeah. Okay, so on this one, a couple of points as well, probably along the lines of what I said before. First of all, regarding the Article 4 and Paragraph 3, suggesting that the CCP should consider the risk management framework and internal control systems of the clearing members. Here we go back to the fact that, yeah, clearing members, they're regulated financial institutions, especially if they have a banking license, then they would already be subject to comprehensive risk management obligations under different legislations. So for us, if CCPs have to dig deeper into whether they comply or not with a risk management framework, it would be a bit duplicative from our point of view. And I think going back to, or paraphrasing Julien, I think it would be like CCPs becoming a quasi-regulator or quasi-supervisor really, of the clearing members, so that we would strongly call to reconsider. Then regarding the onboarding of clearing members from outside of the European Union, there we understand that we need to look, in particular, we would look at default rules, the choice of law, but probably that would be it. Based on the proposals, we wonder that could be interpreted as if we really need to look at almost everything, any laws that would be the clearing member would be subject to in a third country. So we'll probably suggest concentrating on default rules and choice of law as the things to look at, because otherwise it looks like we'll need to enforce, the CCPs will need to look at all these obligations, and that would be a massive increase in cost and legal opinions probably. And that's something that we strongly heard from the whole CCP community, but especially those that have clearing members from outside of the EU. They would be a huge game changer for them to have to do this. Yeah.
Thank you. Any other on this article? Ulrich.
Yeah, thanks. Just a few quick reactions. And one additional point. So again, I think to Raphael's point, not necessarily disagreeing with him. I think it's maybe a level of balance. I reckon it's maybe not meant that CCPs need to be again kind of an auditor or at least kind of a reviewer of a framework. But I can remember that. That when I was sitting on the other side, that CCPs did due diligence meetings where we went through the risk management framework, not in super detail probably, but they looked at the processes and what the bank was looking for. So I think there is probably a level the CCP should be doing. Even though it might be not kind of very the level whatever regulator would be doing. And I think that's probably especially for non-financial counterparties. And I think it was in this article or in the explaining notes to that that you've heard Aina answer. I think that was a very good example that the CCP need to know kind of how much capabilities a firm has, at least to a certain amount. I had another point, but I forgot about that. So I put my hand up again if I remember. But yeah, stay there. Thanks.
Thank you, Ulrich. Any Julien?
Thank you. Maybe to come back to the beginning of the article and a bit of discussion we had earlier on the notion that you can use the fact that you have a member that has a particular license as a criteria. Can you hear me? I think from our perspective, if you look again at how a CCP functions, the way it functions is you have clearing members that mutualize the risks. And those clearing members, depending on the structure of the market, on the structure of the risk we're taking in terms of the products, location, and so on, will want to have a higher bar in some cases. And in fact, we feel that in some cases, the CCP should be able to require that there is a legal status, a license, for example, license of credit institution or equivalent, as a criteria for admission. And just to be clear, I don't think, again, the operating language forbids that. It just says we have to consider whether there's a license or not. But we want to make sure that there's no misinterpretation in the explanatory text that basically says it doesn't mean that you can't accept. I think we need to agree also. I'm making this point because of previous comments. We need to agree that if the CCP considers, again, it's not discriminatory, that we want for a particular service in a particular market to accept only certain type of regulated entities, we should be able to do it. And I don't think it's discriminatory, and I don't think the legal text itself that we have in front of us says that. I have a bit of a doubt, and it's unclear on the explanatory text, but not the legal text. A bit like Ulrich, I had other points, but I can't remember them. So let me just look at my notes quickly. Yes, I think the other point I wanted to make is there's a big difference between the onboarding of the members and the responsibility of the CCP and the responsibility of the clearing members. And I think while we need to make sure that at the moment we are onboarding, the clearing member has a certain number of criteria, the core aspect for a CCP is to make sure that the clearing member has the ability to meet its obligation under the CCP rulebook. And we feel that sometimes some of the parts of the RTS are going beyond that, and we lose a bit sight of the focus. The focus is we need to make sure that they can meet the obligation on a good basis. So I can point to particular instances, but that was a comment I wanted to add. Thank you.
Thank you, Julien. Jean-Pierre.
Thank you. And just off of that point, perhaps to also know that EU clearing members, again, typically EU banks will have access to central bank liquidity. So we're exploring very initial phase of our comments, but we're exploring with our members, again, the importance of distinguishing between capital adequacy and liquidity readiness, and look at, again, where the NFCs stand on this and demonstrate that they have access to liquid assets or committed facilities. So just to the point of really analyzing what they have as available channels. Thank you.
Thank you. Ulrich, do you want to come back?
Yeah, I remembered the point I wanted to make, and B, I want to rec to Julien, because I think it's a good point with his point that there's a difference between the initial review, which is obviously much more thorough than what you would do kind of year on year, and maybe it makes sense to think about to split the requirements a bit between financial and capabilities, because. You could argue that if a CCP has reviewed a clear member and realized they have okay risk management frameworks, this clear member will probably not from one day to the other decide not to have risk management department anymore. So maybe it's more important to focus on this ongoing review on the financials of a clear member, because that is what can change over time. And I know that the CCPs are doing that, so I reckon that's not something that would be new to them. So I reckon it makes much more sense for financials to say kind of CCPs really need to review it as an ongoing thing, but for things like risk management capability, it probably kind of is sufficient if they rely on. If you rely on the initial assessment. So that's that point. And the other point I was trying to make earlier, or kind of wanting to make earlier, but forgot. It's just something that read a bit funny when I read it. You had in a consultation a sentence that CCP's rules should reflect all relevant legal obligations of clearing members from their participation in the CCP, and then brackets, e.g. under EMIR and CCP RRR. I wonder. I think if a clear member is a European clear member, they are subject to these rules already anyway. Was the thinking to somehow via CCP participation make non-European clear members also subject to EMIR and CCP RRR, or is it more level playing field? So it's more a question I have, because I really just didn't get what you wanted to get at with that.
Thank you, Ulrich.
Thanks.
Lucy, you want to react?
Yeah, maybe we can quickly react to this point. So indeed, for example, there was the point on default that Raphael was referring to earlier. Basically, what we are trying to achieve here is that that, let's say, some sort of third country jurisdiction where they would have a completely different default management and what would happen in the case of the default and netting of positions between the clearing member and clients and issues like that. So basically, we want to make sure that all of these protections that are, for example, in EMIR in respect of clients, that if there is a third country a clearing member, that they are able to comply with these requirements.
Julien,
So
you
if
want?
Sorry, may I ask a follow-up question? So would that, for instance, mean that, let's say, if you have a clear member from a country that don't require individual individual segregated accounts, that they would have to do that if they are participant in an EU CCP? So, for instance, would that mean that an US FCM that only can offer the LSOC model if they, I think UX has a rule book, FCM rule book, would that mean that they would have to offer ISA accounts, or is it more basic protections in kind of in default of a clear member, for instance?
We wouldn't go as first of all, as Nicoletta said at the beginning, these are just elements, okay? So they're not the criteria or the conditions themselves, but we would probably stay a bit more high level and would not. I don't think we can mandate via the RTS that the type of accounts that the non-EU clearing member has to offer, but it's more about the basic protections, such as, okay, you cannot net what's in the client's account with the clearing member.
Okay, so yeah, I think that's fair enough, and I leave it to CCPs because they would have to implement it. But now I understand. So thanks for clarification.
But thank you for raising, because if the text is not clear, of course, following the consultation and particularly following this interaction, we will work to avoid, inconsistencies or misunderstandings. Rafael.
Yeah, perhaps I want to come back, Ulrich, to your point. If I understood correctly, I think you may have mentioned the point that CCPs will need to check on an ongoing basis regarding for financials, for example. Would you mind perhaps elaborating on that, because that seemed to perhaps go against what I mentioned before about the lack of possibilities for CCPs to do that, and from our point of view, the inadequacy of them doing that for admission criteria. They would do that from a risk management point of view, of course, but from admission criteria, not. So would you mind perhaps Ulrich clarifying that? I probably misunderstood.
Yeah, sure, happy to. And maybe for me, it's kind of admission criteria are kind of at the end of the day a risk management tool anyway. And I would think that that every CCP is looking at the financial health of a clear member, so I hope they do. And I believe you get at least kind of yearly balance sheets. You have access to, if they are banks, to kind of all sorts of disclosures banks have to do. You probably even look at credit spreads and so on. So I reckon whatever when the Credit Suisse issues happened, I think CCPs were probably not sitting there leaning back and might have waited for the next yearly balance sheet or so. So my point is, I think CCPs probably will look into financial health of a clear member, so they should do, regardless if it's an admission criteria or not. So maybe you're right. Maybe it's more risk management thing.
Yeah, perhaps I can come back to that. So then I think we agree, definitely risk management thing. You mentioned Credit Suisse. I remember that when on the day that happened, we just had a call with each board, and I thought I was doing my wonderful job of immediately asking board members, right, guys, should we do anything? What is? And they all look at me like, Rafael, this already been dealt with for weeks. I mean, we've been monitoring this issue for weeks or even months. So yeah, it's already dealt. So it was check. So yeah, we do that on a daily basis. That's what we were supposed to do. Yeah. Okay, then we agree. Thank you.
Yeah.
Any other comment, suggestion on this Article 4 of our draft RTS? If not, we can move to the additional elements for clearing members that clear transactions on behalf of clients. Rafael, I see from...
Yes, I'm ready for that. Okay, so this is, again, I'm going to repeat myself, but in this case for clearing members that clear for clients. And I'll refer again to the point of the dynamic nature of what we see in the provisions. We are not sure how would a CCP be expected to react if the conditions change, if the relative importance of the client clearing changes in the future. How are we meant to react to that? I mean, that again, we will check this through the normal risk management of the CCP. That is our work. That is our job to do so. But on the criteria, we are not sure how we would do that. And again, there is also a reference to the previous articles. In this article, there is also a reference to the previous articles, and I'll state, the point that, this we do through the risk management framework of the CCP, but we don't think that this is the admission criteria material.
Yeah, I see very clearly that you are pointing out that this split that clearly we will have to work on between what the admission criteria are and what is the ongoing monitoring afterwards. That the message is very clear, Rafael. Other comments on this article or support for what Rafael said? Just give me Maybe a signal. Ulrich.
Yeah, kind of more or less support with what Raphael is saying. Really, just one smallish question to the section. And again, it might be just me misreading the rules. But I understood that you had somewhere in the text, and unfortunately I should have opened it before the meeting. Something that said that CCP should monitor concentrations of clients clients of clear members. So I'm not quite sure how you meant that or how I should have read it. Because I think overall probably it might make sense if you have a client that has a very concentrated position but splits it between several clear members for CCP to know that. But on the other hand, that might conflict with the fact that the CCP doesn't really know who the clients or kind of not always know who the clients are. So yeah, again, that's more a question how this section of the rules were meant. So what we were after. So is it that do you want to know concentration of clients even if it clears between clear members, or was it just looking at concentration of a client of a clear member of that portfolio?
I see that there is a little bit of ambiguity in the drafting, and I understand that we will have to have a review of this section of the document, also in view of what we were discussing before with Raphael, splitting clearly between the admission criteria at the beginning, let's say, of the relationship, and then the ongoing monitoring and the annual assessment that we expect the CCP do of their members, which include also, of course, those providing client clearing services.
Thanks.
Thank you for pointing it out. Other comments on this part of the document, this draft article 5 of our draft RTS? If not, we can move to the sponsored models. And I see that I'm looking at Raphael because representing the Association of CCPs, I'm sure that he has something to react upon, but I also hope that from the audience we will have other comments. Raphael.
Yeah, sorry to monopolize the starts. Yeah, but also on this one, yeah, it's all generally good. That just one point that we see for the moment, and is the requirement to have a backup sponsoring backup sponsoring arrangements. The way we read it is that we should have this backup. And we were a bit surprised to see that, because obviously in EMIR we are not obliged to have backup, or clearing members are not obliged to have backup clearing members for their clients. So I could imagine that the same approach would be applied here. I guess that would be straightforward, but yeah.
Again, maybe if I can react. We are not saying that CCP are obliged to have to have in their rules that clearing members in sponsored models would have a backup sponsor, but perhaps it is something that can be taken into account as a plus when you are assessing whether you want to admit that entity as a clearing member or not.
But of course, we will have to be clear on what are the elements that are necessary and what is maybe something else, because otherwise, of course, it would be difficult to understand. Oh,
Yeah, thank you. I think as a CCP, what we like reading an RTS is to have predictability. Yeah. So we can discuss and we can argue about how prescriptive the regulation should be. It's very important. But to me, the most important is to be able to understand what will be the requirement. And here, and maybe it's come to the shall consider.
we shall consider, but then we'll face our NCA on a day-to-day basis, and the NCA can have a different approach. So to me, shall consider, especially here and globally in the RTS, invite and encourage a lot of interaction with the NCA. So to me, it's becoming
Yeah, I see your point. I see that this is sorry, the micro, yeah, it will be changed because I see indeed the ambiguity of the shall consider. What we have to do are the minimum element that have to be taken into the rule book of the CCP. Then the CCP can decide to go beyond, but what we have to set indeed also in view of the better regulation, the clarity, etc., is the minimum requirement approach. That's very evident from this interaction that we are having, and thank you very much for pointing it out. I see that there is again Ulrich who is willing to come into the conversation. Ulrich.
Thanks, Nicoletta. Yeah, I'm sorry if it's always me popping up. I have to say for this topic, I was really glad to see that you spent quite a lot of thoughts on sponsored models, because I think that's important. Partially because I think this whole sponsored model concept, which I think is important for market. I think you could do repo clearing without it, but it pretty much came up after all the CCP regulation was done, so there's hardly proper regulation around it. And I think there are some things that that maybe haven't really addressed yet. And one of the ones that clearing members are concerned is that in the sponsored clearing model, opposite to the classical client clearing model, is obviously the clearing member is not guaranteeing the client to the CCP. So if a client defaults and if there's not enough initial margin, then it hits the default fund right away. So there's much higher mutualization risk. And for that one, we are quite glad that we looked at that and identified kind of additional requirements that might be necessary for such models. And I think one of the key ones is, and that's something we missed a bit, because I think you have requirements for the sponsor, but you don't have minimum requirements, or you don't say the CCP should have minimum requirements for the sponsored member, because and in practice, obviously, it is like that. In the sponsored models, it's usually mostly larger counterparties. So it's usually larger counterparties. So already, luckily, CCPs don't let everybody in being a sponsored member. And let's say if you're a really big pension fund, that's probably a much different risk for mutualization, as if a CCP would let in whatever Ulrich Karl, very risky hedge fund as a sponsored member. But I think that's a point. I think there should also be requirements to the actually sponsored member, because at the end of the day, it is a clear member. So if they fail, they're not guaranteed by their sponsor, at least not to a full extent as they would be as a normal client. So yeah, I think that's the reason where there should be requirements for them as well. What we really like is your point that CCP should specify very clearly what the split of requirements or responsibilities between a sponsor and the sponsored member are. I think that's quite helpful. Yeah, and I think that is that's the main thing. I see Raphael's point with a backup clear member would be not in line with normal client clearing, but obviously if there is one, it might be again a bit safer for the rest of a community, because then let's say if a sponsor defaults, then the CCP is suddenly having a more or less direct member. And would be probably a little bit safer if this direct member then has another sponsor that can keep doing operational margin payment for them and so on. But I see Raphael's point that it would be on top of what we would do for normal clients.
You wanted to clarify something.
Yeah, Ulrich, there may be some misunderstanding, and maybe we need to clarify the drafting. But Article 6 on sponsored models already sets the elements in respect of members in sponsored models, so sponsored members. This is in response to your comment that we need to also, or we should also set the elements in respect of sponsored members, because it is already there. But perhaps we will look at the drafting again to make sure that it's well understood.
I mean, clearly it's not clear enough, and probably the shall consider approach also, as we were discussing before, adds to the complexity of the understanding. Julien, I think.
It was a mix of a reaction to a point. So you made the point I was going to make is I read that as so in the sponsored model you have what is referred to here as the clearing member. For me, is the entity that is accessing the CCP, and then it's sponsored by another entity which is also a clearing member, and will have criteria itself to be a clearing member of the CCP in the first place. Just how we didn't have much comment on this particular article, and the reason for that is I feel what it says essentially is you should, in your assessment, you should consider whether or not that's how I read it. So I don't read any of that as a mandate. I think, just again, I'm checking my understanding, but for example, in Article 6C, just to make sure we're on the same line, but what I'm reading is you should consider whether they are contingency measures, and our view is that they should be contingency measures because you need to make sure that they're in place. And among those contingency measures, you need to make sure that you have a backup sponsorship arrangement. But that's again, we read that as a consideration, and we didn't find this particularly shocking, but because I'm reading that as something you have to consider and not an obligation, and to Alexandre's point, it might be that we need to clarify this.
That's correct. Yeah, and that is as we said, that is the mandate that we have under level.
Yeah, so the mandate is the mandate, yes, is to indicate the element that the CCP shall consider when establishing the admission criteria. But we have to be clear, also following this intervention, what is the minimum content of the admission criteria in the rule book of a CCP. Any other comment here? Alexandre, you wanted to say something?
No, but maybe following Julian's intervention, when I read clearing members in sponsored model, I think from a terminology perspective, it's not necessarily clearing member, right? So maybe it's participant in a sponsor model.
Well, I mean, commercially or business-wise, you may call it. Sorry, level 1 does not define it, but I think when we say a clearing member in a sponsored model, we mean the sponsored member. But because EMIR only refers to clearing members, we don't want to call it something else. So hence we say a clearing member in a sponsored model. And I think that is also the wording that Article 37 uses, because there is a reference to this in paragraph 7 in the mandate for the.
You say direct clearing members in sponsored models.
Yeah.
So we don't want to use commercial terminology, just
because but I think we refer to the different commercial terminologies in the explanatory part, but that's obviously up to each CCP to decide what they want to call them. But maybe we can try to clarify again in a recital. But since EMIR does not use the word sponsored member, it uses the word just clearing member. This is the terminology that we wanted to stick to.
Otherwise, we will require a definition in the legislation somewhere. I see the point.
Yeah, I mean, definitions in the level 2 are always problematic, as you know very well. But we may try to eliminate ambiguities, maybe through recitals describing what we are aiming at. Okay. Any other, Ulrich, any other comment on this part? Jean-Pierre, on the Sponsored access?
Nothing from me, thanks.
Okay, you need more feedback. So we can jump to the additional element for non-financial counterparties. The Article 7 of our draft RTS that singles out some specificity for the NFCs. Rafael.
Okay, right. No, not me. The each member did. I'm just speaking on their behalf. The each members did. This is all the risk committee of each proposing ideas, and the energy committee as well. And this one in particular is partly in big part because of the energy colleagues. So non-financial clearing members. Well, first, we really like the flexible approach that has been chosen because you would allow CCPs to maintain the admission criteria per product cleared, per membership type. So I think that's per clearing member type. So I think that's great. We'll make obviously again the same point about the idea for CCPs not to reflect the elements on Articles 1 to 6 in the participation requirements, those elements that are more risk management elements. So that's, I think that I mentioned that every single article did apply to this one as well. I have a couple of points, but before I have a question, perhaps there is a reference, and if I'm not mistaken, I think it's just in the introductory text, but not in the legal text itself, the reference to collateral of higher level or even full collateralization. I think there is a reference there in the text. And we were wondering whether the commercial bank guarantees, whether they would meet, from your point of view, these requirements of a higher level collateralization arrangements. Because we saw that in the preamble, but not in the actual text. And obviously, well, the idea would be for bank guarantees to be included, for commercial bank guarantees to be included, in line with what we have been calling for in the past. So any views?
Maybe if I may on this. So on the explanatory part, indeed, we are just having done some research on this and how some of the non-financial counterparties access now the clearing. We have looked at taking some examples as special collateralization arrangements, which can be put in place by CCPs to be reassured when there is not this access to reliable resources like a central bank liquidity. But we haven't in mind in this specific point any specific type of collateralization. We're not trying to be prescriptive there. Then the issue of collateral is being worked internally at ESMA will be dealt with in another mandate, including the bank guarantees. But it's not looking at imposing any specific type of collateralization.
Yeah, we will be doing an ad hoc consultation on that part of RTS 153. But please, Rafael, you add that element.
Yeah, thanks for that. You're looking forward to that one. So thanks for that clarification, Antonio. So on the other points, the NFCs, they in some cases it would be subject to other regulatory frameworks. They may be authorized, or they may be subject to CACAM, for example. So in those cases, we wonder whether, similarly to what we said before for financials, if they're already authorized in a different regulation, could we take that as a check point? And even in the and also we'd like to, and we're still developing these to provide you with argumentation. But even if they are not subject to a particular regulatory framework, we would like them not to be excluded automatically from potentially becoming clearing members. We'll provide you perhaps with more justification of this in this one. Then we're having some discussions still about there is a sentence that says that any prudential regulation and supervision, and we may suggest to change the and for an and or, because in some cases, some NFCs, they are regulated as trading firms, and they may well be supervised. So that could be a check for them. And then finally, it's again about something that the way we understood it could really lead to quite an increase in cost and time burden for CCPs and potentially for the NFCs, and is the idea for CCPs to perform a comprehensive analysis of whether the NFC legislation applies to a particular given activity that they're doing, to assess and evaluate the applicable regulatory regime of the NFC. Again, if we have to do that for all the regulation that applies to the NFC, that could potentially be quite burdensome for everyone. That's why I think is related probably to the first point about whether they're authorized or not and the different legislation. We probably need to clarify this in our response so that it is so that you can see our constructive answer. But we just want to make it easier when it can be made easier because there is already a regulation or a supervision somewhere for NFCs. Yeah. Thank you.
Ulrich.
Thanks. So for that one, I have to say I stumbled over with full collateralization as well, but now good that we have some clarification. So I think some of the points for NFCs chimes a bit with what we said earlier, about how far can CCPs rely on regulation. So I reckon obviously all criteria have in 4.1 to 4.6 are very important to identify if this NFC has enough capabilities, be it financial, risk management, operational, to be a clearing member. Obviously, I think we also agree that just the fact that they are not prudentially supervised shouldn't mean they can't be a clearing member. But that probably means that this is when one of the case where the CCP cannot just look at the prudential regulation, say because of prudential regulation these points are already ticked off. That means we probably have to do some more comprehensive due diligence. And with that, I really just mean into comprehensive due diligence if rulebook criteria met. I fully agree with Raphael. Obviously, that probably doesn't mean to look at every regulation this NFC might be applicable to, if it not really massively interacts with the rule book, but that can be also maybe just representation of NFC itself. I think in terms of arrangement to liquidity sources, obviously NFCs don't have access to the central bank, but I reckon for things like that, the CCP can probably look at whether the NFC has for instance liquidity lines with some other bank or so. So I reckon again that shouldn't mean the NFC cannot become a clear member. It's not a but it's something where the CCP can just see what this NFC clear member, what their provisions are to have enough liquidity to be comply with the rule book at all times.
Thank you, Ulrich. Julien.
I wanted to offer a slightly different perspective on this issue of the license. I think what we're saying, is this licensing is an element that the CCP can take into account, but it's not, again, necessarily a determinant. And we're not saying the CCP has to take on board either entity that have a license or should accept entities that don't have a license. And the reason why I'm saying that is in some cases, in highly sophisticated markets, in fact, I believe the CCP should be in a position to say, to put as an admission criteria the need for a prudential license, and to avoid that we have to do checks on an entity when we know that unless you are a regulated entity, it's going to be very difficult, if not impossible, to hit the bar. So it's what I'm saying is not applicable to all asset classes. I'm very conscious of that. But I just want to make clear that we believe that the RTS itself should not impede a CCP to consider that having a license is a criteria in itself.
Point taken, as we were discussing with Rafael, before we allow for different criteria depending on asset classes, etc. Perhaps we can elaborate a little bit better.
I think this is already in level 1, that CCPs are basically free to set different criteria for different products, different asset classes. So of course, for more sophisticated clearing services, you may set more stringent criteria. That's already explicitly allowed under level 1.
And to be clear, I see that almost as a proportionality aspect, in a sense that that is also a way for the CCP to not have to conduct first principle assessments on each and every entity that comes to the CCP. Say, I want to be a member of RepoClear, for example. Say, well, you're not even a bank. You don't even have any financial surface. How are we starting this assessment? And so we should be able, from a proportionality perspective, to say, we think you should be a credit institution to even start looking at the repo market. The repo market might be a bad example, but just where I'm coming from is there.
Also, level 1 says that you may limit access based on risks. That's the only legitimate reason. So as we said, the criteria can be different for the very sophisticated markets. It can be more stringent than for others. So it's already, that flexibility and proportionality is already embedded in level 1.
Yeah, maybe we can clarify and make the link and make sure that nobody can read this as a different approach. Pedro, I think. Pablo.
Thank you, Nicoletta. Just very briefly, to build on what I said before, in my view, it would be useful to have an addition on operational capacity in Article 7, something to the effect that where the non-financial counterparty is not subject to DORA, the CCP, which I guess is the vast majority, if not all of them, the CCP shall consider whether it is subject or applies an equivalent regime. Thank you.
Point taken. Thank you very much. Jean-Pierre.
Very short comment, as we're still assessing, but we're assessing different entities' participation in the default management process and whether that raises any further comments from FIA. But apologies, it's early on our end.
Benjamin?
Yeah, thank you. Here, Benjamin from Deutsche Börse Group, and thanks very much for putting up this very valuable discussion, both Nicoletta and team. Maybe just adding to what we were talking about in regards to setting access criteria based on the product being cleared based on the specific membership type. I think it very much makes sense to have the ability to set stricter criteria for more risky activities and markets. But I would also like to highlight the point that this could go the other way, right? Like, obviously, the way to address these membership criteria, you can make an in-depth check and check if the potential clearing member can meet similar requirements as a financial institution would have anyway. Or it might also be possible for the CCP to simply design a membership model in a way that those risks are already addressed in the model itself to ensure that the respective risks wouldn't come up in practice. So could be pre-funding the positions, right? Could be pledging back repo collateral directly to the CCP, but there are ways of addressing certain risks in a way that might make certain admission criteria then not necessary anymore. And as far as I understood, especially from the recitals, I think it was recital 2, this is also partly the intention of the RTS. But we think in the future discussions, especially as you're considering maybe amending things, this should hopefully be taken into account as well. Thank you.
Thank you.
Yes, thank you. I think also we should be mindful about the discussion around clearing thresholds that are happening right now, and to force entity to that have sufficient activity to clear and to pass trade through clearing, to not squeeze some NFC that might be forced to go to a clearing house but not meet certain criteria. So both of them should be coherent.
Antonio, you want to react?
No, just on that point, can you please elaborate a bit? Sorry, not sure I understood everything.
So right now there are discussions, especially at ESMA, to establish levels. If you breach a level, an entity should be mandatory to clear its activity through a clearinghouse. And especially for NFC, they might be squeezed between the requirement here within this RTS and this obligation, this clearing threshold.
Thank you. Are there any other comments from the virtual audience or here from the room? Other suggestions? Because this was the last article in the draft RTS. And if there are no other contributions or other comments, we could go to the end of this public hearing. As I said, we will look forward to receiving the individual responses. We know that the association are still consulting internally, but we are very keen to see your detailed comments. We will start already reflecting on the basis of what we have discussed today. A number of indications are clear, also to eliminate a number of ambiguities. But we look forward to the written contribution. As always, they can be published on our website, but if you prefer to send them in a manner that remain confidential at ESMA level, we also accept this type of responses, which will not then, of course, be published and put at disposal of the wider audience. Rafael, please.
Yeah, one more point that we still have not discussed in detail, that is the application. So the time of application, they're coming into force. So I see that for the moment in the RTS, it talks about X number of days or something along those lines. We still haven't discussed that. So it's a genuine question. I don't know whether we will be calling for a particular time or not, but I could imagine that probably CCPs will need some adaptation period to adapt the rules, to get them through compliance, through legal, etc. So I guess we would also be commenting upon that in our response to try to come up with a suitable time. It will take some time, perhaps not overly long, but definitely more than the usual sort of 20 days in the EU legislation. I think it will be more than that.
Yeah, there could be a difference between the entry into force and then the deadline within which the rules will need to be amended. Of course, you know, this will also finally depend from the decision of the European Commission, but we can certainly try to frame it in a manner that it distinguishes the date from the entry into force of the regulation and the date within which the rules will have to be amended and the new criteria applied by the relevant CCPs. Thank you for this useful comment. Any other last final comments? If not, I thank you very much for participating, and I close now the public hearing and the virtual room. Thank you very much.